As far as Catherine goes, she doesn't really matter in this. The problem is in the system, my kids are what doesn't matter. And that's who it should be about. It should be about protecting the children. It should be about protecting victims. It should be about the victims' rights, not the people who are portraying the crimes against them.
Today's hearing was brought about in response to a motion filed by Ms. Hoggle's attorneys regarding whether or not she could be continued to be committed at Clifton T. Perkins Hospital for an additional period of time. It is the state's position that the clear reading of the applicable statutes in question would indicate that Ms. Hoggle, who was found first on December the 1st, 2017 by Judge Mason in this court to be incompetent to stand trial for the murder of her two children, could be held for a period of 5 years from that date. It was the state's position today in court that it was premature today to hold a hearing on whether or not the charges against Ms. Hoggle would be dismissed.
People want to make conclusions about what happened in this case, and that's not really the procedural posture. The procedural posture is one of law. Ms. Hoggle has been charged. First in the district court, she was charged with a series of misdemeanors, and then she was charged with felonies here in the circuit court. And the real question is, if she's been incompetent for the last 5 years, which she has, and the statute says if you're charged with a felony and you've been incompetent for 5 years, those charges need to be dismissed, are they going to be dismissed?
Under the law in the United States, based on a Supreme Court case, individuals who cannot be restored to competency cannot be held indefinitely awaiting trial. That is why we were in court today. Maryland has a statute that says the maximum period of time you have is 5 years. Ms. Hoggle has been at Clifton T. Perkins for 5 years, but she was initially there on child abduction and child neglect charges. Later on, the state upgraded those charges to murder. Murder is a felony, and the statute quite clearly states that the state has 5 years when you are charged with a felony to have you restored to competency.
I feel like so far Judge Greenberg has seemed to be very fair, and I would like to just publicly thank him for allowing me to speak today and for hearing me out. I feel like the fact that it can be a compelling story of what's happened, how a lot of people can be confused by, and there's been a lot of kind of, I don't know if you want to call it twists or whatever. I feel like the fact that it's two human beings, two tiny, small human beings, my children that were taken from me, gets kind of lost in what the storyline could be. And, and then like I said in there, like some people have referred to this as a mystery. There's absolutely no mystery here. Catherine Hoggle planned and carried out her plan to murder my children.
I will tell you that the judge was concerned about whether or not he could continue to hold her based on a recent report that he received in this matter. It had to do with the concept of restorability to competency. It is the state's position in court and now that it is premature for the court to deal with the issue of restorability. My position and the position of my office is that we have till December the 1st, 2022. At that time, if Ms. Hoggle has not been restored to competency, the issue of restorability would be ripe, but it is premature to do that now.